If you work on tugboats and get injured, your employer is probably going to tell you to file a workers' comp claim. They'll hand you the paperwork, tell you it's standard procedure, and act like workers' comp is your only option. They're wrong, and they know it. I'm maritime injury attorney Matt Schaefer, and in this video, I'm going to explain why tugboat workers have special rights under federal maritime law that are worth significantly more than workers' compensation. The confusion happens because tugboat work doesn't fit neatly into most people's idea of maritime work. You're not on a cruise ship. You're not working on an oil rig in the middle of the Gulf. You're often working close to shore, sometimes in rivers and harbors. It feels more like regular industrial work. But tugboats are vessels in navigation, and if you work on a tugboat, you're almost certainly a seaman under federal maritime law. Let me start with the legal definition. To be a seaman under the Jones Act, you need to meet two requirements. First, your work must contribute to the function of a vessel in navigation. Tugboat workers clearly meet this test. You're operating the vessel, maintaining it, or supporting its navigation mission. Second, you must have a substantial connection to the vessel. The law uses what's called the 30% rule. If you spend at least 30% of your working time on a vessel, you're likely a seaman. Most tugboat workers spend 100% of their work time on the vessel. You live on the boat during a rotation. You work exclusively on the water. You're definitely a seaman under the Jones Act. But here's what happens in the real world. Tugboat companies often treat their workers like shoreside employees for legal purposes. They file workers' comp claims. They act like the maritime law doesn't apply. They hope their workers don't know the difference. Why would they do this? Because workers' comp is much cheaper for employers than the Jones Act claims. Let me show you the difference with a real example. I represented a tugboat deckhand who was crushed between two barges when a cable snapped. He suffered multiple fractures, internal injuries, and permanent disability. Under workers' comp, he would have received his medical bills and about $800 a week in temporary disability payment, and then a little bit more money in permanent partial disability benefits. Total value would be certainly less than $300,000. But as a Jones Act seaman, his rights are much more valuable. He has a right to sue the tugboat company for negligence, the right to be compensated for his pain and suffering damages, the right to choose his own doctor. There are no caps on his compensation, and he's protected from retaliation. And in that example, the case settled for $1.9 million. Same injury, same worker, but understanding that he was a seaman under the maritime law made a $1.6 million difference. Now let's talk about the specific way tugboat workers create Jones Act claim. Equipment failures. Tugboats use heavy, powerful equipment in challenging conditions. Winches, cable, towing gear, deck equipment. When this stuff fails, people get seriously hurt. We have handled cases involving snapped tow cables that whip across the deck, winch malfunctions that crush workers, deck equipment failures that causes falls, hydraulic system failures that causes burns or crushing injuries. In each of these cases, we're able to prove that the tugboat company was negligent in maintaining their equipment. Under workers' comp, negligence doesn't matter. Under the Jones Act, proving slight negligence can be worth millions. Tugboats operate in tight spaces, busy harbors, narrow channels around bridges and docks. Collisions happen, and when a tugboat hits something or something hits the tugboat, the crew can be thrown around the deck or bridge. I represent a tugboat captain who suffered a traumatic brain injury when his boat struck a bridge piling in heavy fog. The company had pushed him to continue operating despite weather conditions that made navigation dangerous. Under workers' comp, it wouldn't have mattered that the company pressured him to work in unsafe conditions. Under the Jones Act, however, that pressure constituted negligence, and the case settled for $3.2 million. Most of tugboat work involves pushing or pulling barges. This creates unique dangers: getting caught between a tugboat and a barge, being struck by shifting cargo on barges, falls due to uneven deck surfaces, injuries from connecting or disconnecting towing gear. The key legal issue often is whether the barge was unseaworthy, meaning it wasn't fit for its intended use. If a barge has defective cleats, uneven decking, improperly secured cargo, or other dangerous conditions, that's unseaworthiness. Unseaworthiness is a separate claim from Jones Act negligence. You can win both, and that can significantly increase your settlement value. Even if you're not sure you have a Jones Act negligence claim, you're definitely entitled to maintenance and cure if you're injured while working on a tugboat. Maintenance is money for your living expenses while you recover. Cure is payment for all your medical treatment. Many tugboat companies pay insultingly low maintenance amounts, maybe $40 or $50 a day, but the law requires them to pay your actual living expenses. If your rent or mortgage, utilities, food, and other necessities cost $4,000 a month, that's what your maintenance should be. I've had cases where just fixing the maintenance and cure payments added $75,000 to $150,000 to the total settlement value. Some tugboat workers think the Jones Act doesn't apply to them because they work in rivers, harbors, or close to shore rather than the open ocean. That is wrong. The Jones Act applies on any navigable waters. That includes rivers used for interstate commerce, harbors and ports, the Great Lakes, coastal waters, offshore areas. If your tugboat is pushing barges, carrying cargo, or towing vessels, or doing any kind of commercial navigation, you're working on navigable waters and the Jones Act applies. I've successfully handled Jones Act cases for tugboat workers who never left the Mississippi River, who only operated in Houston's ship channel. Location doesn't matter. What matters is that you're working on vessels and navigation. This is what you do if you're injured on a tugboat. First, report the injury immediately and get medical attention. Don't let anyone talk you out of seeing a doctor or going to the hospital. Second, don't sign anything beyond basic incident reports till you understand your rights. Don't sign workers' comp forms. Don't sign releases. Don't give reported statements to insurance adjusters. Don't admit to fault. Third, document everything you can remember about how the accident happened. Take photos if it's safe to do so. Get names and contact information for witnesses. Fourth, understand you have time to explore your options. You generally have 3 years to file a Jones Act lawsuit. Don't let anyone pressure you into accepting a quick workers' comp settlement. Fifth, and most importantly, talk to a lawyer who specializes in maritime law before you make any decision. Most personal injury lawyers don't understand the Jones Act. You need someone who handles these cases regularly. Here are some red flags to recognize if your employer is trying to avoid the Jones Act. They immediately start the workers' comp process and act like it's your only option. They tell you the Jones Act doesn't apply because you work close to shore or that you're in the river. They pressure you to sign forms or accept settlement offers quickly. They claim the accident was your fault and try to get you to admit fault in writing. They offer you a lump sum settlement that sounds generous, but doesn't account for your future medical needs or lost earning capacity. Tugboat work is dangerous. The Bureau of Labor Statistics consistently ranks commercial fishing and maritime transport among the most dangerous jobs in America. Tugboat workers face unique risk from heavy equipment, dangerous weather, challenging navigation, and the constant danger of being caught between massive vessels. When you're injured in this kind of work, you're not just dealing with a temporary setback. You're often looking at permanent disability, career-ending injuries, and lifetime medical needs. Workers' comp might cover your immediate medical bills and provide some temporary income, but it won't compensate you for a lifetime of chronic pain. It won't pay for the fact that you can't do the physical work you've done your entire career. It won't account for the impact on your family life. The Jones Act will, because the Jones Act recognizes that maritime work is inherently dangerous, and when the employer's negligence contributes to that danger, they should be held fully accountable. If you work on tugboats and you've been injured, don't just assume workers' comp is your only option. You're most likely a seaman under federal maritime law, and that means you have valuable rights that are worth significantly more than workers' compensation. Make sure you understand those rights before you sign anything or accept any settlement offers. Next, watch my video on what the Jones Act is and how it works so you understand the full scope of your rights as a maritime worker. And if you've been injured on a towboat and want to know if the Jones Act applies to your situation, there's a link in the description for a free consultation. We've handled thousands of these cases nationwide, and we only get paid if you win.